Why don't we...
Okay, New York, call to order here. New York State Racing Parimutuel Wagering and Breeding Law, Section 102 provides that the New York State Gaming Commission shall consist of 7 members appointed by the governor by and with the advice and consent of the Senate. 6 members having been confirmed by the New York State Senate affords the commission an ability to establish quorum and undertake action. This present meeting of the commission is now called to order. Ms. Secretary, will you please call the roll?
John Crotty.
Here.
Mark Guerin.
Present.
Peter Machete.
Here.
Don Paclemba.
Here.
Barry Sample.
Here.
Todd Snyder.
Here. This is a very...
Ms. Secretary, please have the record reflect that a quorum of qualified members are present, thus enabling transaction of business. Chairman Guerin?
Great. Thank you very much, Rob, and good afternoon. We'll begin with consideration of the minutes from our September 30th meeting. Minutes of the Commission meetings conducted on that date, September 30th, 2014, have been provided to members in advance, and at this time I'd like to ask the members if there are any edits or corrections or amendments. Madam Secretary, please let the record reflect then that the minutes were adopted. I'm just seeing acknowledgement. All those in favor? Good. Great. Thank you all. Next, we turn to the report of our Executive Director. Rob.
Thank you. Given the length of the rulemaking portion of today's meeting, I'm going to try to be very brief here. The Gaming Facility Location Board has met on 3 occasions to discuss financial and employment histories of those applicants responsive to the request for application to develop and operate a gaming facility in New York State. Their most recent meeting occurred this past Friday when they met at Hofstra University. While information relative to the board's review and deliberation has been scarce, it is my understanding that they have tentatively scheduled December 17th in Albany for their final meeting. The other item that I'd like to talk to you about is the Zweig Fund. The Harry M. Zweig Memorial Fund for Equine Research recently conducted its annual meeting at Cornell University's Ruffian Equine Specialist Center, which is across the street from Belmont Park. The Zweig Fund, which receives its funding indirectly from Racing Handle as a pass-through from both the Standardbred and the Thoroughbred Breeding and Development Funds, is statutorily charged to promote equine research at Cornell University's College of Veterinary Medicine. The fund annually solicits and reviews research grant proposals. This year, the fund received 18 proposals requesting over $1.8 million in funding. The committee ultimately chose to award or to fund 8 grants in the cumulative total of $619,000. The fund's work is very important as it provides for the study of critical issues relative to equine health and issues of significance for the racehorse industry. This year's proposal allows study of diseases such as strangles and equine herpes virus 1, equine osteoarthritis, and enhanced breakdown screening through multimodal imaging and serum biomarkers. This past meeting was also significant as it marked the final service of Dr. Zweig's widow, Anna. Mrs. Zweig, who is also a Cornell alumnus, has been a member of the committee since it was founded in 1979. She determined to relinquish her seat and not seek reappointment. The Zweig family, however, remains represented on the committee through the service of their son, Brian. Chairman Guerin?
Great. Thank you very much. Our agenda will now turn to rulemaking, and we have a busy agenda here. New York State Racing Parimutuel Wagering and Breeding Law 104.19 authorizes the Commission to promulgate rules and regulations that it deems necessary to carry out its responsibilities. To that regard, the Commission will from time to time promulgate rules and rule amendments pursuant to the State Administrative Procedure Act. And today we have 8 rulemaking items for consideration, and Rob will outline the proposals.
Sure. Item 4A regards rules pertaining to gaming facility request for application and gaming facility license application. Specifically, on March 31st, 2014, the Commission promulgated emergency rules prescribing both forms for the request for application to develop and operate a gaming facility and several forms that were necessary to consider and process applications for gaming facility licenses. By publication in the State Register on July 16th and again on September 10th, the Commission extended the emergency adoption. This present emergency rule will expire on December 21st, 2014. Accordingly, for Commission consideration is the readoption of Part 5300 as an emergency rule, with such readoption to be filed with the Department of State prior to the expiration of the current emergency rule. The text of the rules has not changed since the initial emergency adoption on March 31st. While the public comment period has expired and no public comment was received, permanent adoption of this rule should be considered when the Commission has before a broad set of proposed commercial casino regulations that are still in the process of being drafted. Commission staff recommends readoption of this emergency rulemaking.
Thank you, Rob. Commissioners, any questions on the readoption of the rules pertaining to the gaming facility requests for application and gaming facility license applications, with such readoption to be filed with the Department of State prior to the expiration of the current emergency rule? Questions for Rob? So may I have a motion then to readopt the rules pertaining to the gaming facility request for application for gaming facility license application? So moved. Moved. Seconded?
Sure.
Great. Any discussion on the motion? All in favor?
Aye.
Opposed? The motion carries. Our next items, Rob?
Items 4B through 4G all regard thoroughbred racing. In November 2013, the Commission proposed a variety of rules designed to protect the integrity of the parimutuel wagering system and the health and safety of thoroughbred horses engaged therein. Specifically, hold on just a second, if you would. Thank you, Rodney. Specifically, the Commission considered amending its existing rules to create regulatory thresholds for 24 drugs that have widely accepted beneficial effects and can be effectively regulated by means of laboratory thresholds. The adoption of these same thresholds is occurring at other racing commissions throughout the nation. Other proposed amendments related to Commission's rules restricting the time period after various drug treatments before a horse may participate in a race and rules relative to specific drug utilization. These proposals are necessary to harmonize rules that forewarn a trainer when to stop using each particular drug with the new thresholds. The proposed rules were the subject of a public hearing conducted January 21st, 2014. Information received at that hearing resulted in reconsideration of certain rules relative to standardbred racing. Those rules remain in the process of review and are not yet ready or ripe for Commission consideration. Thoroughbred rule modifications, however, were considered and re-proposed with a few revisions at the Commission meeting conducted on March 12th. Overall, it is important to note that the centerpiece of the thoroughbred rules, the 24 threshold, has not changed since the initial proposal in November of 2013. Commission staff sought industry and general public input on the proposed rules no less than 4 times. Pre-proposal, initial proposal, the public hearing, and the revised proposal. Substantive comments from 2 organizations were received regarding the thoroughbred rule proposals. Both were generally supportive of the drug testing changes. As a result of the hearing, the Commission may make fact findings in regard to rulemaking proposals. Staff strongly recommends this approach given these rules present the first major new regulatory approach in New York equine drug testing since the Racing and Wagering Board adopted restricted time periods in 1982, and they are thus likely to be challenged, much as the restricted time periods were challenged back in 1982. Findings of fact provide the best opportunity to ensure that there is a clear and concise record of the agency actions regarding the scientific consultant's analysis and considerations in establishing these rules. If made, fact findings would constitute resolved facts for all relative adjudicatory proceedings before the Commission. Staff has prepared for consideration a memorandum identifying 9 agency findings for 4 rule proposals. Overall, staff recommends the adoption of each of these 5 rulemakings and 9 findings of fact. Staff also recommends 1 proposed rule regarding restricted time period for administration of unspecified corticosteroids in thoroughbred horses be withdrawn as moot, given the rule proposals that are before you now. Today we have with us State Equine Medical Director Scott Palmer. Dr. Palmer would like to briefly address the science that underlies the proposals. Additionally, on the telephone, we have the Director of Racing, Ron Okram, and Assistant Counsel, Rick Goodell. Collectively, they should be able to answer any questions that you might have relative to the rules before you. Dr. Palmer?
Thank you, Rob. I participated in the rulemaking public hearing on January 21st, and I have reviewed all the written submissions and public documents in order to prepare the agency-specific findings with regard to these key issues. Whether adopting thresholds is consistent with the agency's regulatory approach, whether these thresholds are consistent with our other rules that are already in place, and whether we have proposed appropriate adjustments to our restricted time periods to accommodate adopting the national thresholds. Dr. George Malin, who is the longtime director of the New York State Laboratory for Drug Testing and Research, has also reviewed these issues and the draft findings. We both are sure that these findings, based upon a review of all the industry and public input and applying the institutional knowledge and the expertise of Commission staff, are accurate and sufficient to set forth the Commission fact findings for adopting the proposed rules. I personally support this approach to regulating medication in horse racing, and it's my own professional opinion that adoption of these proposed rules is of critical importance to New York State horse racing. Adoption of these rules will position New York as a leader in concert with our neighboring Mid-Atlantic states in establishing uniform medication rules for horse racing throughout North America. Because these rulemaking proposals represent a significant change regarding the regulation of certain classes of medication, it is important for the Commission to set a date for implementation that provides for ample opportunity for licensees to prepare for these rule changes and to take steps to comply with them. We will announce these changes and provide guidance to horsemen and veterinarians on the Commission website. I'm working with Lee Park to create a broader communication vehicle for trainers and veterinarians using both the website and social media that will be ready in the near future. If you have any questions, I'd be happy to address them.
So, Judge Barr, what would be the effective date? What's your recommendation?
We're recommending January 1. There is one particular medication.
2015.
Yes. There's one medication, methylprednisolone, which if a trainer had given the medication to the horse today or yesterday, it could be as long as 50, 60 days before the medication is cleared. So if we enact the rule right away, it's possible that some people could get caught up in the transition inappropriately, and we want to avoid that at all costs.
That's the depot.
That's the depot.
Doctor, I don't know, this might be a question for you, it might be for Ed. What happened when I was reading this, and I wasn't here in 2013 or March of 2014, but you guys had essentially made a recommendation and then revised that, right? And I was reading, it had to do with, says the threshold for unapproved drugs. Can you tell me what happened there? Just.
Well, we were trying to incorporate uniform national medication policy, and the initial proposal was made by the Association of Racing Commissioners International in conjunction with the Racing Medication Testing Consortium, included eliminating a large quantity of medications with the zero threshold tolerance, and then they changed their minds. We proposed it, the national organization changed their approach, and we were caught in the midst of the problem of, well, how do we proceed then? We had to really withdraw that first proposal and rewrite it in conjunction with the national rules, so as we go forward, we're in concert with the national rulemaking proposal.
Why, though? I mean, I assume when it was proposed initially, everybody was comfortable with that, or you guys?
No, that's not true.
Okay.
There was controversy about that, and the controversy centers around the fact that there are a large number of medications that are not addressed by these 24 rules, these 24 thresholds, and that if we completely make them all illegal, that would inappropriately restrict the medical care of horses who may not even be racing at that time. So it was a very complicated issue. There was a lot of discord about it, and as soon as the national rule was proposed to the different racing jurisdictions, there was a tremendous amount of pushback. And then the ARCI came back and said, okay, fellas, let's leave that alone for now. We're just going to focus on regulating this group of medications.
So if the national organizations hadn't reversed their positions, then we would have stayed with the proposal, the original proposal out of 2013?
I don't think we could have gotten industry consensus on that initial proposal, and that was the problem nationwide.
I just think that for New York, maybe that it's a good time to lead on those issues. And I understand the ramifications, and we have to be sensitive to that. But when I read that, I just thought, New York, that might be one of those steps that the public really wants to see. And I understand their concerns because if you eliminate certain medications, it might have a deleterious or inappropriate effect for the horses. I understand that. But I thought that seemed to be a step in the right direction. And then we kind of reversed course because, as I read it, and I wasn't there for the discussion, but, well, everybody else doesn't want to do that, so we're not going to do that.
I think that most...
Maybe I'm simplifying.
No, I don't. I think that's pretty close, but I think the overriding concern is this, that we race in an area, this part of the country, where a trainer could have horses racing in 5 or 6 different racing jurisdictions at any one time, and the rules have been different leading up to now. And that it's an extremely important thing to have a national uniform medication policy. The Jockey Club wants it, ARCI wants it, RMTC wants it, the AAP wants it, everybody wants it and needs it badly. If New York can lead by getting this national rule policy done and then adjusting it from there, but to go off in a direction that would be contrary to national uniform rule medication would be very harmful to New York and for the whole process going forward.
You mean harmful to racing?
It would be harmful to racing nationally.
At the time, if I remember correctly, you'd said, if we do this national policy, then we could implement on top of that whatever, because there was a theory as to why you had any drugs in grade 1 races and, maybe 2-year-old races. And right, I don't want to speak for you, but I remember it as such. They were saying, yeah, well, if you had a uniform drug code that was more than we had ever had before, and that was across those states, and then you could adopt that. I would love to go there, too, I think.
I'm just thinking we might wait forever to get there, though.
Not if this gets approved, though.
Well, but we're not approving what we really wanted to do, right?
Well, I think it's important to understand that we can get these things done. And if you'll note, in these rules, we already have recommended some additional issues. For example, this issue of Depomedrol, the methylprednisolone. You notice that we've put in here an additional rule that is not in the national rules. It says that if you really want to use this medication, because it's so difficult to regulate it, you have to go on the VETS list. And you can't race until you test negative to get off the VETS list. That's not in any other rule in any part of the country. This is just one example of how in New York we are leading the way and trying to make sure that these national rules are really well done and that we don't have issues in this state like there have been in some other states. And so I think that there is also, I will share with you that Rick Goodell and I are working on some additional prescription medication rules that will be superimposed on all this stuff. It'll help tighter regulation of all prescription medications in New York. That will be a very good step forward, but we didn't have that ready in time to present it to you today. But that's coming.
I know Rick is on the line. Rick, did you want to add anything to this discussion?
No, I agree with what Dr. Palmer said.
Dr. Palmer, I know you spoke about the website and working with Lee, but getting the message out to veterinarians and others in this timeline, you're comfortable with our capacity?
I believe we can. I believe we can get it done shortly. We can certainly use the website immediately. We can use the overnight sheets. We can use contacts with the HPPA and the New York Thoroughbred Horses Association and the State and National Veterinary Association. So I think we can get the word out well. But I think Lee and I are very sensitive to the fact that as time goes on, we would like a more immediate listserv type situation where we can actually directly contact all licensed veterinarians, all licensed trainers in New York to advise them to change to these new rules. We just don't have the database in place to do that just yet.
Lee, anything else to add?
No, we're working on it. We're moving towards it. We don't have the exact end date yet as to when we'll have that mechanism in place, but it is something we're moving towards.
Any other questions or comments, Dr. Palmer or Rick or anyone? Well, given what we've heard from Dr. Palmer, I have a motion then to authorize the effective date of these rules, January 1st, 2015. Motion?
Yes.
Great. Second?
Yes.
Great. So the following rules that are before you, but I'll just read them into the record, regarding per se thoroughbred regulatory thresholds for equine drugs, regarding the use of corticosteroid methylprednisolone, get that?
Methylprednisolone.
Acetate and thoroughbred racing regarding a restricted time period for systemic administrations of corticosteroids to thoroughbred horses, and regarding limiting betamethasone,
Methylprednisolone.
thank you, and trimetaclone to only joint injections in thoroughbred racehorses, and regarding a restricted time period after IV administrations of flexnixin to thoroughbred horses. Motion's been made and seconded. All in favor?
Aye.
Aye. Opposed? The motion carries. Now, Rob, did you want to speak to...
Yeah, well, as we've mentioned before, you also have before you a memorandum relative to 9 agency findings as fact findings that are relative to this rulemaking that you just undertook. As I mentioned, the fact findings would therefore establish certain facts for all administrative hearings that outflow relative to these 24 thresholds. The reason why it's not on all the rules and just on some of the rules is one of the rules had changed and therefore was not subject to that hearing. So therefore, you couldn't make findings of fact based upon the hearing relative to that rule that changed. But in front of you are 9 agency findings regarding the new rules.
Okay, so we need a motion then to adopt the 9 agency findings of fact findings, as fact findings. Do I have a motion?
So moved.
John, seconded?
Sure.
Thank you. Any discussion on that motion? All in favor?
I'm sorry.
Please.
I'm
Please,
late
go ahead.
to the bell there. I was reading, is it Benamine? Is that one of them?
Benamine.
Yeah.
Nixon, yeah.
And then I think there was some talk of there has been some confusion among the trainers and some of the others about how that it's administered, and there's a different, I guess, time period when it's done by way of joint or interarticularly. Is that what you say?
So Nixon is given systemic. It's not given in the joint.
It's not.
No,
Okay.
it's a systemic medication. It comes in formulations which can be given as an oral paste, for example, or it can be given intravenously. And the confusion that happened in some respects was that some trainers didn't appreciate that the withdrawal times would be different for an oral administration than for an intravenous administration of the same drug concentration. And that caused some problems, and I think we've addressed that.
Okay.
But is that what you're referring to?
Yeah, that was the issue.
Any other discussion on the motions been made and seconded? Great. All those in favor?
Aye.
Opposed? Motion carries. Now we also have the motion, we would invite a motion to withdraw the previously proposed rule regarding a restricted time period for the administration of unspecified corticosteroids to thoroughbred horses. So this is the withdrawal. Do I have a motion for that?
So moved.
Seconded?
Second.
Any discussion on the motion? All in favor? Say
Aye.
Opposed? The motion carries. Rob, can we turn to you now for the next?
Certainly.
motion?
As item 4H for Commission consideration is a draft regulation refining the current rule that sets forth grounds for the suspension and revocation of a lottery license. Current regulations require a sales agent, as a condition of licensing, to comply with the licensing agreement and any rules, regulations, procedures, policies, and instructions promulgated or issued by the Commission. The lottery sales agent license agreement contains an obligation, as a condition of licensing, that the agents achieve a level of sales required by the lottery. The proposed amendments would make explicit that failure to meet such obligations is grounds for suspension or revocation of a sales agent license. The amendments would add other grounds for suspension or revocation, including violation of the licensing agreement, violation of the conditions of licensing, and non-cooperation with or frustration of a Commission investigation. To protect the licensed sales agent, the amendments would also require that the Commission to notify the sales agent of a sales deficiency in writing and set forth a time which the sales agent could illustrate satisfactory improvement. The amendment would also allow the sales agent to raise, as an affirmative defense to the suspension or revocation based upon insufficient sales, that the agent's sales performance is reasonably excused by factors outside the control of the agent, or that the agent has taken reasonable steps to mitigate. Examples of some are extreme weather, natural disaster, flood, earthquake, war, discharge of hazardous material, blackout or power interruption, civil unrest, or other events and circumstances. Other revisions to the proposed rules are to eliminate duplication of statute, align the provisions for winding up terminated sales agents' licenses with preferred practice, and to make stylistic changes. Today on the telephone we have with us Gardner Gurney. He's the director of the Division of the Lottery, and he can answer any questions along with Ed that you might have relative to this proposal.
Any questions or conversation? Well, I'll entertain a motion then.
I have one question.
Please.
Does this come within our delegation of authority? Is this something that we have delegated to the staff to make these determinations?
This is actually the first step of that. This is a rulemaking to actually establish that we can create these criteria. As to the specific delegation, Ed?
Right. Well, then the implementation, once you make the rule, would devolve to staff according to your delegation to implement it.
At any point, would this come before us to make an adjudication with respect to a license revocation?
It could, yep.
In a manner similar to horse racing, where an individual's like...
Yes.
So it would be the same process with respect to violations in the horse racing area. We would deal with that the same way, and we would have before us appeals, say, of license revocations.
You could, yes.
Those rules already established. We don't need those rules.
Those rules are already established, yeah. This is really to refine them, to make explicit that if someone doesn't comply with their conditions of licensing, that's a grounds
as opposed to just merely qualifying for the license.
Yes.
Right, I got it.
And we haven't had any of those appeals as of yet.
We have not.
Not during the Commission's tenure.
Thank you. Sorry.
That's good. Well, may I have a motion then to propose rulemaking regarding grounds for suspension and revocation of lottery license? So moved. Seconded?
Sure.
Great. Any further discussion? All in favor?
Aye.
Opposed? The motion carries. Okay. We next turn on our agenda to adjudications, and the Commission has 4 hearing officer reports for consideration today, and I'd ask Rob to outline the first case.
In the matter of Aaron Byron, on March 21st, 2014, the presiding judge at Buffalo Raceway issued an 8-day suspension of driver Aaron Byron for interfering with another horse in the 3rd race, in violation of Commission Rule 4117.4L. Following Mr. Byron's appeal, a hearing was conducted on August 8, 2014, at which Mr. Byron failed to appear. The hearing officer's report and recommendation were delivered to the Commission Secretary on October 30th. The hearing officer recommended that the Commission sustain the license suspension. At a meeting conducted pursuant to the judicial or quasi-judicial proceeding exemption of the New York Public Officers Law, Section 108.1, the Commission considered this matter.
And the Commission duly deliberated and considered this matter and determined with a unanimous vote to sustain the hearing officer's report and recommendations. The matter of William Creech.
On May 15, 2014, the Bureau of Licensing declined to issue a thoroughbred stable employee license to William H. Creech on the basis that his, quote, experience, character, and general fitness are such that his participation in racing-related activities would be inconsistent with the public interest, convenience, or necessity, or with the best interests of racing generally, unquote. Following Mr. Creech's appeal, a hearing was conducted on July 1st. The hearing officer's report and recommendation were delivered to the Commission Secretary on October 7th, 2014. The hearing officer recommended that the Commission sustain the license denial. At a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of the New York Public Officers Law, Section 108.1, the Commission considered this matter.
The Commission duly deliberated and considered the matter and with a unanimous vote, sustain the hearing officer's report and recommendations. Next matter, Barry.
In the matter of Barry Held, on August 15, 2014, the Bureau of Licensing declined to issue a standard-bred horse owner's license to Barry Held on the basis that his experience, character, and general fitness are such that his participation in racing or related activities in the state of New York was inconsistent with the public interest, convenience, or necessity, or with the best interest of racing generally. Following Mr. Held's appeal, a hearing was conducted on October 3, 2014. The hearing officer's report and recommendation were delivered to the Commission Secretary on October 5th. The hearing officer recommended that the Commission sustain the license denial. At a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of the New York Public Officers Law, Section 108.1, the Commission considered this matter.
And the Commission duly deliberated, considered the matter, and determined on a unanimous vote to sustain the hearing officer's report and recommendations. Matter of Jack Rice.
Final matter, the matter of Jack D. Rice. On April 18, 2014, the presiding judge at Buffalo Raceway fined driver Jack Rice for delaying the start of the 10th race in violation of Commission Rule 4115.2A. Following Mr. Rice's appeal, a hearing was conducted on September 25, 2014. The hearing officer's report and recommendation were delivered to the Commission Secretary on November 3, 2014. The hearing officer recommended that the violation be upheld, but a fine of $50 be imposed.
Commission duly deliberated and considered this matter and determined upon a unanimous vote to sustain the hearing officer's report and recommendations. So that concludes our adjudications section of our agenda. The next item is new and old business. Do any of the commissioners have any matters to consider here? Anything to bring before the commission? Any old business? Well, I guess we'll next then turn to our scheduling of the next meeting. The date of our next scheduled meeting is December 22nd. And please advise Ms. Buckley of your availability. So with that, that concludes today's published agenda. Do any commissioners have any items that they'd like to present for consideration? Anything else before we... Well, hearing none, this meeting of the New York State Gaming Commission is adjourned. Thank you all very much.
Thank you.
You're welcome. Thank you.